The Supreme Court on Friday stayed an Allahabad High Court judgment which had struck down the Uttar Pradesh Board of Madarsa Education Act 2004 as unconstitutional. This judgment of the High Court was said to impact the future education of nearly 17 lakh students and 10,000 teachers. So in this video, I, Apoorva Mandhani, will tell you what this law says, why did the High Court strike it down, and why has the Supreme Court now stayed this High Court judgment. Now, the 2004 law essentially allows the state government to establish an Uttar Pradesh Board of Madarsa Education, which was then empowered to impart education from primary level to postgraduate and research level. The statement of objects and reasons of the 2004 law says that the law was being introduced, and I quote, with a view to removing the difficulties arisen in running the madrasas, improving the merit therein, and making available the best facility of study to the students studying in madrasas, unquote. However, in its judgment passed last month, the High Court declared it unconstitutional, ruling that the law violates the principle of secularism. The High Court had also asserted that the education being imparted in madrasas is neither quality nor universal in nature, referring to the subjects being taught by the Madarsa board. Looking at the provisions of the law, the court then pointed out that the definition of madrasa education under the law includes Islamic studies. It then looked at the syllabus of primary classes, that is class 1st to 8th, to note that Quran and Islam among other subjects are taught in every class. Similarly, in class 10, theology, Sunni and Shia are compulsory subjects, while only one optional subject is required to be taken from amongst math, home science, which is only for girls, logic and philosophy, social science, science and medical science. The court therefore said that the scheme and purpose of the Madarsa Act is only for promoting and providing education of Islam, its prescriptions, instructions and philosophy, and to spread it. In addition to this, the court also said that it is the duty of the state to provide education which is secular in nature, and that it cannot discriminate and provide different types of education to children belonging to different religions. This, it said, would violate secularism, and observed, and I quote again, such an action on the part of the state is not only unconstitutional but also highly divisive of the society on religious lines, unquote. The High Court had then also directed the state government to take steps to accommodate these students in regular recognized schools, since there are a large number of madrasas and madrasa students in the state of UP. However, this judgment was then challenged in the Supreme Court, and before the Supreme Court, the petitioners refuted the High Court's finding that modern subjects were not taught in the madrasas and submitted that math, science, Hindi, English, etc. are taught. They also questioned the High Court's reasoning that if religion is taught, it will amount to religious instruction and will violate secularism. They cited judgments saying that teaching Sanskrit, Hinduism or Islam will not per se become religious instruction. Senior advocate Dr. Abhishek Manu Singhvi, appearing for one of the petitioners, also asked, and I quote, "We have also very famous gurukuls in Haridwar and Rishikesh doing very good work. My father has a degree from there. Do you shut them down saying they are places of religious instruction?" unquote. Senior advocate Dr. Menaka Guruswamy also submitted that the act ensured that the 16,000 madrasas, out of which 500 received aid from any form from the state, had a particular standard and followed a curriculum. If the statute is taken away, it will mean that they are left unregulated and the standards will fall. Now the Supreme Court has stayed this judgment, and in doing so, the court said that the Allahabad High Court prima facie erred in understanding the provisions of the 2004 Act, which are regulatory in nature. This is what the court said. The Supreme Court said that the Act does not provide for any religious instruction. It specifically referred to the finding of the High Court that the very establishment of the board would violate secularism. The Supreme Court said that this finding appears to conflate madrasa education with the regulatory powers of the board. The court also said that if the concern was to ensure that the students of madrasas receive quality education, the remedy would not lie in striking down the Madarsa Act, but in issuing suitable directions to ensure that the students are not deprived of quality education. So now, observing this, the Supreme Court has stayed the High Court judgment. Of course, we'll be keeping track of what else happens in the case in the future, and we'll keep you updated on every update that comes out of the Supreme Court in relation to this case. Thank you so much for watching.